Okay, so here are 5 very common Social Security disability hearing mistakes. And the whole point of this video is to kind of explain to you the basics of what you need to know going forward when you're approaching your Social Security disability hearing, right? So you got a denial at the initial filing level, a denial at the reconsideration level, and you want a fully favorable or partially favorable at the OHO hearing level. Here's what you need to know. Number 1, at the end of your Social Security disability hearing, right, whether you're seeking SSDI benefits or SSI benefits, you need to shush. And here's why. When the judge asks you if there is anything you would like to add at the end of it, please, for the love of God, only give any additional impairments that were not originally discussed as prior, in the earlier parts of the hearing. Do not do a story about your dog. Do not do a story about things that you think the judge will like to hear about. Do not self-incriminate what you basically said you didn't do before, couldn't do before, and now you can do. Just don't do that stuff. You absolutely, no matter what, do not deliver your best friend wedding speech, because you're going to self-incriminate yourself with comments about what you can do and comments about, what you want to do, and you're just going to screw it up. Don't go in and do that stuff. Number 2, have the basics covered. The top 5 impairments, when they began, when they became severe, why they became severe. How do you know they became severe? 2 symptoms/signs per each impairment. If you don't know the difference between a symptom and a sign and you're walking into your Social Security disability hearing, you should not be going into that Social Security disability hearing. If you are in that position, you need to go learn the difference between a symptom and a sign. Those are basics. That's the basics, okay? Medications. What are their side effects? If you don't know what the names of your medications are, then there's a big problem. I don't care if you have 5 medications, 10 medications, 15 medications. You have no right to not know the names of your medications and what their side effects are if you are going into a Social Security disability hearing. Okay? Why you can't work, like the whole friggin' part of this system. Why you can't do your past work, why you can't do other types of jobs in the national economy. Now remember, there's some snobby people out there, some snobbers, right, who basically are trying to go ahead and, basically they won't work any other job in the type of industry they were in. That is not what the judge cares about. The judge cares about, are there any other jobs in the national economy that you could potentially do no matter how shitty they are? Let me give you an example. These other jobs, okay, just to clarify, just to give you some examples here, they are things like price checker, okay, where you're sitting on a line and you have to flip a product over so it goes to the next person, okay, or basically a price marker. You're putting marked prices on items, okay, or maybe you're at a cashier station, or maybe you're digging a hole somewhere, or maybe you're mopping a floor somewhere, or maybe you're doing stuff with postcards, or maybe you're doing stuff with postage. Basic jobs. The question is never, can you do your past work at the amazing rate at which you were doing it, in which they loved you at that company and gave you all those awards? No. Bad claimant, no. That's not what the standard is. The standard is, could you do any job in the national economy? Any at all. Okay. So once again, top 5 impairments, when they started, when they became severe, what are 2 symptoms/signs per each, medication side effects, why you can't do your past work, why you can't do other types of jobs. If you don't have those basics down, like if you don't have that written out, figured out ahead of time, you shouldn't be going to this disability hearing. You really have no right to screw up your life without having that at least ready. Okay. Number 3, know the 4 to 5 sections of the hearing. Know them. They're simple. They're easy. They're so easy. They're melted cheese easy, okay? Number 1, there's the intro of the hearing. I swear to tell the truth. The attorney talks with the judge, works out the housekeeping stuff, which is one of the things I always think is interesting. I have claimants tell me, I went to a hearing and, the judge, we went right to, I swear to tell the truth, and, ready to go. I was like, what did you fix the amended alleged onset date? Did you go through this? Did you go through the problem with the Medicare? No, I don't know, blah, blah, blah. And that's one of the big things. Right up in the very beginning, the attorney is there to fix the general problems with the claim, the housekeeping stuff, the stuff that the judge is sitting there going, well, I'd love to approve it, but for this saying this on the ERE. Point is, the intro is important. Not for you, but for the general housekeeping of the claim. Cameraman, thank you for the 99-cent donation. That's absolutely awesome. Very, very cool. Thank you. Scales, Tales in Life, very cool. Howdy. I see Diana there. That's awesome. Now, with that said, okay, there's section 2. That is from the claimant's perspective, the scary part. That is from the claimant's perspective, the, oh my God, what will do? I don't know what I'm doing, but do. Right? That is the, that's the tip the cowboy hat, cry a little bit, tip it back up, and then drink your beer. Right? That's what that is. That's your 20 minutes sitting in the hot seat answering questions from the judge and the attorney on direct and cross-examination. Know the questions and the answers that you're going to give. Right? If you're going to go into this hearing and you haven't been practiced on knowing the questions and the answers ahead of time, let's call it like it is. You shouldn't be doing the hearing. Number 3, that's where the vocational expert comes in. Vocational expert gives testimony, hypotheticals. Well, really, the judge gives the hypos. The vocational expert gives responses to those hypotheticals as to potential jobs that you could do in the national economy. And remember, it's a hypothetical person. It's not you. So bottom line is this. The hypothetical individual goes ahead and gets limitations. You guys always hear right up front, oh, they could do this job, whatever. Almost most hearings, they give at least 3 jobs that you could do, which means that the first hypothetical gives a version of you that is not very limited at all. Right? That first hypothetical, that's a swing and it hits you straight in the chest because the judge says, give me 3 jobs based on this hypothetical. The vocational expert says, here are 3 jobs. The judge says, well, look at those 3 jobs. Then the judge gives hypo 2. What if I changed it to be this? What if I changed it to be that? What if I changed it to that? And then ultimately you end up on work preclusive, meaning there's no jobs in the national economy. And then your brain hears no jobs in the national economy. So you're automatically thinking, I've got it in the bag. No, you don't. You don't. The judge can choose the answer, the output, the vocational experts, hypothetical choices from each one of those options. Hypo 1, they could choose that. Hypo 2, they could choose that. Hypo 3, they could choose that. The judge is not required to choose the one that you like. The judge can still choose a hypo where you could potentially do work or, there's a motorcycle. No, sorry, that's a heavy rocket. That's a very big rock. I can feel the whole house doing the thing. So the judge is allowed to go ahead and choose whichever hypothetical the judge wants, whether you like it or not, based on what the judge thinks your limitations actually are. All right. Now then there's section 4. That's the outro. We went over the outro a little bit. Do not go into your wedding speech. Be polite. If it's telephonic and the judge says we're off the record, thank you so much, you hang up. You get off the phone and call your attorney and ask your questions. The questions are always the same. How did I do? How did I do? Right? The questions are always the same. Where did it go? Did I do great? Did I do great? Most of the attorneys will tell you that you did very well, 3 to 4 months, you'll get a decision, and then boop, the attorney's off the phone. Because the attorney doesn't want to spend too much time because they want to get to the next claim, work to the next thing, keep it rolling. Okay. However, I don't do that. The way I do it pisses people off sometimes. I tell them what they did well. I tell them what they screwed up. I tell them the issues that are going to be coming forward if they get a denial. And I ruin their goddamn day. I surely do, because they need to know both sides. They need to know if it's leaning this way or that way. Sometimes, most of the time, I get the leaning right. Judge is leaning this way, cool. Sometimes I get it wrong, and that's partially because the writer will change the judge's, mind down the line. Here's the thing. There's a 5th section. It usually comes in after the intro, where they bring in a medical expert. Medical expert gives testimony as to whether or not your impairments limit your ability to do functional tasks. Okay. The medical expert will say, this impairment and this impairment would cause these limitations, yada, yada, yada. And then the judge would use that as part of the adjudication. Sometimes medical expert is there because it's a complex medical situation. Sometimes the medical expert is there because the judge just wants to do a quick hearing. Thank you, medical expert. Sounds like an approval to me. Attorney, do you have any questions? Nope. Vocational expert, I'm good. Cool. And the hearing done. Number 4 of 5 of the 5 most common disability hearing mistakes. This one's important because this one has become more and more obvious and more problematic. Yes, Charlton Zimmerman, that's a rocket, big rocket. I live by that area. Number 4, don't listen to people who have had disability benefits for more than 7 years. I beg of you, I pray of you, I hope that you will not listen to people who have had disability benefits for 7 years or more. They are horrible, horrible liars. They sometimes mean well by it. Sometimes they're just trying to feed their ego. They don't know what they are talking about. They are extremely dangerous. And they usually are just trying to feed their ego when they tell you how the disability world works and what the culture is and what the rules are. Ignore them and what they are saying at all costs. They don't know the modern program. They are found disabled before a lot of the big changes. They don't have your best interests in mind. Usually, even family members. I've been amazed to hear family members say some of the things that they say. I'm just sitting there like, what the F? They don't, to be fair, they use these tactics and they explain these things to you, but they don't know what the culture of OHO is. They don't know what the judges are doing. They don't know what the rule changes are. They're just going by how it felt while they were going through it. So if you're going to listen to them, that's fine. But remember, either they tell you that's how it was when I was there, and you use that disclaimer, or in your head you say, this person hasn't been in this system for quite a long time. There's been a lot of big rule changes. Therefore, I should take it with a grain of salt. Okay. This is something that people who are applying for disability benefits need to know. The people who have had disability benefits for a long time, they come out with these comments that are just egregious. They're absolutely terrible. Oh, it only took me 2 weeks to get disability benefits. Yeehaw! I was able to get this added on, this added on. It only took me one conversation. Only took me a Band-Aid, and I had to pull it right off, and I was ready to go. You have to understand, these people do not live in the current world of disability. They were found disabled in a different era. And now almost every day, multiple times a day, I get phone calls from people who have been on disability benefits for 10 years, 15 years, 20 years, 30 years, and now they're going through a CDR. They're showing improvement. They weren't doing what they're supposed to do. They were just going by their own advice, and now they're losing their benefits. And now we have to fight to figure out whether or not we can take it and fix it and make it right. Okay. The community of the disabled has a lot of people suffering from anxiety and depression, especially right now more than ever. And those people that are on their benefits and realizing that the benefits aren't enough and they can't afford the things that they used to be able to, and realistically, the inflation, deflation situation has harmed them immensely. They're not in a good spot. They can feed off the feeling needed by people who are nowadays applying for disability benefits. They feed off them. They play off their insecurities. They grab them and they tell them, this is the way it is. But the reality is they have no freaking clue. I would say the greatest enemy nowadays of people seeking disability benefits would be taking advice from people who received them 7+ years ago, especially 15 to 30 years ago. Holy cannoli. That is a dangerous person to listen to. They have literally no idea at all how the modern program works unless they study it. Some of them do, and it's really good, and it's really awesome, but most of them do not. And what they do usually is give incredibly bad advice. And then somewhere down the line, I get the claim because it's all screwed up. There are some mistakes you make that I cannot fix. There's some bad advice you take that I can't rectify. There was a claimant about a month ago who had such bad advice, they screwed up the claim so badly. I had to say to them, look, at this point, you're going to have to refile. Because the culture is, when you do this with the SSA, when you do that thing, what that person did, they will deny you at each stage until you refile. Because it was epic bad advice that ultimately led to the claimant getting banned from the local field offices. And I know a lot of you are like, no, I've got the good news. And I hear you. But just tell everybody when you tell them and they're looking to file for benefits and they're, just remember, be strong with them and say, but that's how it was when I went through. or this might not be how it actually works now. Because let me tell you, I mean, there's a lot of people that are desperate seeking benefits who have less than the people who already have benefits that are desperate because, everything is inflated and, they can't afford anything and yada, yada, even with their benefit. So I get it. But please be kind to the fellow people who are applying for disability benefits. The comments where you're like, I was able to get on in 3 weeks. I don't know what's wrong with your claim. I don't know what, you must not be that bad. Save it. They don't need it. People have to be far more severe than you were back in the day to be found disabled. Just save it. You were found disabled in the golden era, the era where it was amazing. But now it's not that. It's just not that. Number 5, don't assume the judge finds your jokes humorous. Some of the judges have really dark humor. A lot of people who go through law school end up that way because they practice and they see the darkest side of humanity, the absolute worst of the worst, doing the worst of the worst to humans who sometimes deserve and sometimes don't deserve the worst of the worst. So a lot of us have very dark humor. We don't have Disney humor, although Disney has gotten very weird over the past couple of years. But the bottom line is we essentially usually have a darker humor than most people. And some of them are watching the clock as you're trying to give testimony at your hearing. And they have zero time for your antics. Stay away from anything political, and things about the judge's personal life are a big no-no. When you make the statement, and I know some people are going to be like, well, that's obvious. It's not obvious because people do it all the time. And if I have to bring it up, it's not obvious. If you, the claimant, have to say to the judge, well, Your Honor, it's just like with your kids. Well, Your Honor, it's just like with your husband. Well, Your Honor, it's just like how you would do it at home with your family. If you do that, you have effed up. Because now you've just made a personal statement about somebody who has to remain neutral, and they may not like that you are in their personal zone, which you should never be in. And as a result of that, just to make it very clear, you want to stay out of that. Politics, that's easy to understand. Don't talk about blue, don't talk about red. Stay out of it, okay? The big thing is, if you do it right, and I've been thinking about asking the claimants if I can post the actual hearing recording. I've been thinking about doing that. But the point is, and I think this is incredibly important, if you do it right, you're not going in there trying to schmooze the judge. That's not how this works. You're trying to use the evidence that exists, a slight bit of flair, a slight bit of getting them to like you, but mostly why you should be found disabled because you can't work the simplest jobs in economies that you partake in and are in other states. Any state in the national economy, they compare you. What jobs are there? That means when they look, and this is why it's so unfair, they look at jobs that you could potentially do. They look at Alaska. They look at Maine. They look at California. They look at New Hampshire. They look at Texas. They look at Florida. They look at Idaho. They look at all of them, all the states. And what it comes down to, and this is the really tricky part about it, is that you have to prove that there is absolutely no job there that you could do full time. Not in the back of your head what you say, oh, I can't do it. I just can't do it. No, you have to actually prove it. You have to have failed work attempts. You have to not be able to do certain functions required by that job, lifting things, getting things from up high with both hands, being able to go ahead and, bend down and get things from a bottom section, being able to interact with the general public, being able to put up with your coworkers. I know that's the toughest. I know. You have to be able to understand what the judge is looking for. And if you're going in there being like, you're on a schmooze, blah, 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 you're wasting time. Nobody wants your story mode. Nobody has time for it. The judge has more hearings before you and after you. The attorney has more hearings before you and after you. Final thought, number 6. I always like to give you a little bit extra. If you go hire a law firm, you should hire a law firm that does disability law. I know you're like, I get that. I mean, I knew that, obviously. No, you didn't. Because the grand majority of you don't hire a disability law firm. You hire some giant PI firm that does a little bit of disability to be nice to their personal injury claimants who were really messed up from something that happened. They do it as a side gig. They don't do it as their thing. They don't do it as this is where our money comes from, so we better do it the best that we possibly can. Then some of you guys will hire literally, like, not even law firm. You'll hire like some insurance company that basically has non-attorneys like working the claim because your one insurance company told you to hire this other insurance company that does this function. I gotta tell you, I mean, how would you even get to the decision to hire an insurance company recommended by your insurance company to go ahead and represent you? Like, how could you get to that choice? Like, you would have, there's like so many red flags. Like, imagine you're at a restaurant, right? And they got those cute little drink, like those little drink thingy umbrellas, right? Imagine buying from Costco an entire bag of those, opening each one. You just shove it at your own face because what would you think? You're hiring an insurance company recommended from an insurance company to represent you? Like, there's not even anything good about that. It's all bias. Why would you do that? You keep your legal situations with separate legal entities. You got a workers' comp claim, you get a workers' comp attorney. You got a disability claim, you get a disability attorney, right? Disability is like VA and SSDI and SSI. That's all boop. You want an LTD attorney? That's long-term disability insurance. You go get an LTD attorney. You want a personal injury attorney? You want a maritime attorney? You want a wills, trust, and estates attorney? You want a this, a that, a this, a that, a this. You go get each individual one. I guarantee you're not getting a BOGO deal. And the BOGO deal, if they do have one, is not to your benefit. God, please, just keep that in mind, all right? Somebody in the comments is going to be like, I knew that, because they've been on disability for 7+ years and they know everything. God, I had one lady call me up. She pissed me off so much. I was just, and everything out of her mouth was questioning me. And I had to then, in my brain, I've learned when you get a VA person, and there's 1% of them out there who constantly questions you and manipulates you and tricks you and does this and this and you have to shut them off and end the phone call. Because no matter what, every time you fix the dumb thing that came out of their mouth, whatever you fix, they got one in the chamber just waiting. They just got that one in the chamber and they're just willing to give it to you. And I just, I have learned especially, and usually there are signs too. Like, I know, I've been around this long enough. I know when I get a call from somebody and they're like, I've got 4 kids in Thailand and I don't want to pay child support. How do I work this with my VA and my disability benefit? I know when I get those calls, I'm on the brink of the 1%. I am. I know it's coming. I can feel it coming. All right. Those are the 5 most, plus the number 6, right? The 5 most common Social Security disability hearing mistakes. I hope this helped you. Please remember to like and subscribe and go to Google and type in disability resolution law firm, disability resolution, Florida. If this video helped you in any way, it takes a couple of seconds to Google disability resolution Florida and hit the review button, 5-star or 5-star. And I like eating tacos too. I think disability law is boring, but you make it less boring and a little bit annoying. Anything is good. Just remember, when you hit the 5 stars, it is weird when we get really positive comments with a 1 or 2 star. You guys got to click the rest of them. That's so important. All right. With that said, like and subscribe. I go live on Tuesdays and Thursdays usually, where I go ahead and answer questions for free, where people call in. If you need more than 5 to 7 minutes of a free me answering stuff, you always have the hour option. That's where you can basically reach out. You can hire me for an hour. I put you for an hour on the hearing schedule. The little mini contract is below. I will catch you in about 15 to 20 minutes for the last video. Drew Beal, thank you for the $4.99 donation. Love the little beach pic there. That's awesome. That was the first super of the live stream right there. I will catch you guys at the next video. I'm probably not going to do the big one that I wanted to do, but I'll probably do a smaller one. But there's a saucy one coming out, and it's all about 1983. And it is not a happy video. It is a saucy, drippy video. I'll catch you a little bit later. If it takes me 15 to 20 minutes, that's because I did not eat a panini. But if it takes me about 25 to 30 minutes, there was a panini involved. I'll catch you later, and I'll see you soon. All right. Thanks so much, everybody. All right. Catch you later. Bye-bye. Bye-bye.